Thanks, Macca. And even though we're supposed to be looking towards the future, Macca's given me a subtopic which gives you a bit of a history lesson. So he's asked me to look at the question, the IR consensus, has it broken down? Well, there's an assumption in that question that there was or is an IR consensus, and I'd suggest to you that there is not and never has been an IR consensus. What there probably has been is a fairly long period where the Labor Party took a more progressive view to IR laws and legislated in a manner that was consistent with that view. It was along the trend line that the other parties supported, but it certainly wasn't a consensus position. Labor did this because way back when, in the 70s and 80s, they realised that they needed to bring about change in the economy as a whole, and they realised the only way to achieve that was to get the unions on board, because those of you who are old enough to remember those times, there was union penetration in the workforce of something like 50%. So if you're going to bring about any sort of change, you needed support. They did that through a whole range of agreements known as the Prices and Incomes Accord, where they got the union movement on board to bring about change, or at least not to oppose significant change in a whole range of areas. In the area of industrial relations, what it meant was the unions would moderate their claims, and in return the government would provide them with a social wage, as it was then determined. Medicare is a classic example of that. Superannuation was another element of that. And for a significant period of the 80s and 90s, we had progressive change in industrial relations. To say there was a consensus, these two would be examples of people that would suggest there was no consensus. On the left hand was a business leader of some prominence of the 80s and 90s, and probably earlier than that, a guy named Hugh Morgan, who led an organisation which was quite significant during that period, known as the H.R. Nichols Society. I think they still exist today, but they are far less significant than they were. But he was certainly pushing for more radical change, and he didn't suggest that the changes that the Labor government was then implementing were significant enough for him. And amongst his supporters and co-founders of the H.R. Nichols Society were prominent people such as Peter Costello, our longest serving treasurer. On the right-hand side is a guy who most people, I'll give you $100 if anyone in the room can tell me who the person on the right-hand side is. Michael Kent's looking intently. He might be able to tell me. I'll have a word to him quietly afterwards to see if he would have earned the $100. But that's a guy called Jim Staples. He was a commissioner in the Conciliation and Arbitration Commission, as it then was. In 1988, the Hawke Labor government replaced the Arbitration and Conciliation Commission with the Australian Industrial Relations Commission, brought in legislation. Part of the reason of that new legislation was to create a new tribunal which allowed them to appoint new commissioners. Every prior commissioner was reappointed, except poor old Jim. Jim was not appointed to the new commission because he was considered too radical. And that was an example of Labor bringing about progressive change of a significant nature, but certainly not as radical as Hugh and others might have wanted. And so we did have a period where there was progressive change. We had the 88 Act, we had the 93 Act, which brought in unfair dismissal laws at a national level, that brought in enterprise bargaining. We had the 96 Act, which was the first act of the Howard government, which endeavoured to bring about more change, but most of the significant change was blocked. And then we had work choices. So if there was anything close to a consensus, work choices broke that consensus. And why that was significant was it showed political opportunity being taken to overreach, and what it has led to is that Labor now believes that they have a very significant tool, so that if they wanted to make progressive change, they are more reluctant to do so because they can bang the coalition over the head with work choices, and any significant reform in industrial relations they can use to their political advantage. So, going back to whether or not there was a consistency in view, you can break up the key components of industrial relations laws into 6 areas, and I've done it in this way on the slide. The first is the right to strike, and to the extent there was a general acceptance of what the law should say in this area, it probably said strikes are available to workers, that is, they are available to withdraw their labour at certain circumstances, but it should be highly regulated. And the sort of wildcat strikes that occurred before the Hawke-Keating era and for part of the Hawke-Keating era should no longer occur into the future. I'll suggest to you that that idea is broken down in recent times. Enterprise-focused bargaining has certainly been something that's been accepted or has been in place for the best part of the last 3 decades. I'll question whether or not that still is a view that's broadly held. There's been a belief that minimum conditions should be set by an independent umpire, the Australian Industrial Relations Commission in the past, more recently the Fair Work Commission. Whether that now is accepted as appropriate is up for question. Discrimination laws had generally, up until a few years ago, been recognised as an appropriate part of our legislation. Live and let live was essentially the background to discrimination laws, but in recent times, not from the left but from the right, we've seen some questioning of whether or not those laws should remain. In the area of work health and safety, there was a general view that we should have nationally consistent laws, and we moved towards that in 2012. In more recent times, even though we didn't get absolute consistency in more recent times, that also has broken down. And finally, Macca asked me to raise WorkPack, Skane and WorkPack, which is a question about casuals. Prior to recent times, there was an understanding that if you engaged a casual in accordance with an industrial instrument, you could rely on that categorisation of the employee as a casual for all other purposes. In August of this year, that was thrown into significant doubt by a decision which I'll briefly talk about. So going through those 6 areas where we previously thought generally the law wouldn't radically change in this area, we're now having the ACTU, and to some extent supported by the Labor opposition, suggesting that regulated industrial action should change reasonably significantly. The union movement suggests there's far too many restrictions on their ability to strike, and they want that to change so that we may end up with a circumstance where, if supported by legislation, there's a real question around that, where industrial action will occur in a much less regulated manner. In terms of enterprise-focused bargaining, again, the union movement is saying to us the focus of collective bargaining should be broader than enterprise-based. They want it industry-based. For some industries, in the bus industry, that wouldn't necessarily be a radical change. There still continues to be some form of industry-based collective bargaining. Victoria's an example of where that occurs. But the union movement is suggesting far broader than that, so that enterprise bargaining could occur, collective bargaining could occur not with an enterprise focus, but with an industry-wide focus, and that would be a significant change. In terms of minimum conditions, we previously had the Labor opposition supporting the concept that the Fair Work Commission would be the independent umpire that would establish minimum conditions in Australia set through awards. They maintained that position while a case was before the Fair Work Commission on penalty rates for public holidays and Sundays, and then they changed their position when that decision came down. That's a pretty significant change in arrangements. We've now got the Labor government saying they will legislate to implement a return to relevant penalty rates in the retail and hospitality industries. We don't know where else they might determine to regulate if they don't agree with what the independent umpire says. There's been other areas where the neutrality of an independent umpire setting minimum conditions has been broken down. In this industry, in Queensland, we've seen the state government intervene to encourage increases in minimum rates for a very small subset of the workforce, namely bus drivers who work on Q Connect and TransLink contracts. That's a very small group of the workforce, the Queensland Government has set up a fund to subsidise increases in minimum wages. It'll be interesting to see whether that expands beyond that narrow subset of workers that they're supporting at the moment, more broadly within the bus industry, or indeed more broadly within industry more generally. We're also having state governments involving themselves in industrial relations in other areas. They're setting, in South Australia, Queensland and Victoria, they've decided to regulate the labour hire industry and set up a licensing regime there. In South Australia, that legislation has now been removed with the new coalition government there, but we'll see what happens elsewhere. We're having state governments talking about wage theft legislation. So again, we're getting a move away from what would have been considered the accepted middle position to one where, instead of centralised minimum conditions being set by an independent umpire, we're seeing those conditions sometimes being set by governments federally and at a state level. In the area of discrimination, we previously had a level of understanding that our discrimination laws are about right. In two areas, the Coalition have suggested that they weren't about right. One is in relation to race discrimination, and we had the former Attorney General famously suggest that we need changes to race discrimination laws to protect the rights of bigots. Ill-chosen words, but nevertheless showed a reasonably significant change. At the moment, we've got a freedom of religion inquiry underway. Well, it's actually been completed and a report's been presented to government, but not yet made public, which suggests there might be a change whereby discrimination based on religion would be able, or the inability to discriminate based on religion might trump other areas of discrimination. So that's again a change in what might have otherwise been considered the centralised norms. In work health and safety, as I mentioned, we were moving towards consistent national work health and safety laws, aiming to have all laws around the country the same by 2012. That largely happened, with the exception of Victoria, but in more recent times we've seen further breakouts. Queensland again is one of the states that have broken out, and they've unilaterally changed the model laws by introducing industrial manslaughter laws with significant increases in potential penalties for those who breach the laws. Finally, in relation to casuals, the position that most employers understood to be the case prior to August of this year was that if you engaged a casual in accordance with your award or other industrial instrument, most obviously an enterprise agreement, then if they were properly engaged pursuant to that industrial instrument, then they would be a casual for all other purposes. The full federal court, late in August of this year, put that into some doubt in a decision involving Workpac and an employee known as Skeen, where the full bench of the federal court determined that an employee may be a casual for their award or enterprise agreement purposes, but may not be a casual for the purposes, in this case, of annual leave accrual. The ramifications of that decision are still being determined, but we certainly don't have a consensus in how the fallout from that decision should be dealt with. The Labor opposition have indicated that the decision is appropriate, but they haven't really explained what the solution will be, because we know that there are potential very significant back pay claims that could be brought if the decision is followed through. We've got the coalition government looking at it, but we don't yet know what their solution is. We've got employer groups taking different positions on this. So the AIG have indicated that the decision should simply be reversed and the position prior to the decision should be reinstated, which seems the most appropriate outcome for employers. After all, the casual loading compensates, indeed many would suggest more than compensates, for the temporary nature of employment, and that's what AIG has been suggesting. We've had other employer groups make application to the Fair Work Commission for a new award category, which is some form of permanent casual position which would not actually fall foul of Workpac. That would resolve the matter moving forward, but it doesn't resolve the problems going backwards. finally, before I show my own mug, which I shouldn't do, not this early in the morning anyway, finally, we will have, if the polls continue to show the likely outcome of May's election next year, a new federal IR minister, and that's who's on that slide, Brendan O'Connor. The question we're asked, and I finally get round to that, is whether or not, rather than what I've been asked to look at is there an IR consensus and has it broken down? I think the question really is, will we have radical change in our IR laws in the period ahead? And whilst in opposition, Labor has probably put forward a platform that is more radical than we'd like to hear, I suspect in government they will be more pragmatic. I say that for two reasons. One, because both O'Connor and certainly Shorten as union officials were more pragmatic. The statements coming out of Labor differ depending upon their audience. So we saw Albanese not so long ago, and he's talking later today, so he might be able to clarify this, was certainly talking about having a business-friendly approach in government, and hopefully that will be the case if Labor come to government. The other good reason why we won't see radical IR changes in our laws is because we still have a Senate which the Labor Party won't control, and I think that will make a significant difference. So we never had an IR consensus. We certainly had more predictable views than we currently have. You can certainly mount a case to suggest that the whole scheme is about to fall apart, but I certainly don't believe that's going to be the case. I think into the future we will have, if Labor comes to power, a moving of the dial back towards more union-friendly laws, but I don't think it will happen in a significantly radical way. But I'll be interested to see what my friends have to say about that.